Hey guys, TINUBU may lose presidency as powerful lawyer makes explosive revelation about his drug case. Details will surprise you. Hello everyone, welcome back to Prospect Channel TV. Thank you for always coming out here. If you are just joining us, please kindly subscribe and don't forget to give us a thumbs up. Thank you. A lawyer, Barrister Adu Mahmood, has reviewed that the question of whether the forfeiture can be taken into consideration in irrelevant to the petition that the Labour Party presidential candidate filed against the All Progressive Congress presidential candidate Bola Ahmed Tinubu, allegedly that Tinubu should not have been permitted to run in the February 25th presidential election due to his forfeiture of $460,000 to the US government in 1993. Beware that Atiku Abubakar of the People's Democratic Party (PDP) and Peter Obi of the Labour Party, who plays third and the second respectively, are contesting Tinubu's election on a number of different grounds. Obi is pleading with the court to disqualify Tinubu for his involvement in narcotics trafficking in the United States. The APC leader was charged by Obi with running multiple bank accounts that participated in both money laundering and the receipt of heroin trafficking revenues. Obi presented a widely disseminated court affidavit from the United States District Court for the Northern District of Illinois, Eastern Division, asserting that Tinubu was in fact the account owner and that as a result of owning the account that were seized, he was in fact a co-conspirator in the drug trafficking crime. Barrister Adu Mahmood, however, claimed in an exclusive interview that Aisha Yusuf uploaded on YouTube, saying the first leap of Obi's petition is not a matter of fact, it is a matter of law, and the position of Obi is founded in the whole question of forfeiture that took place in America 29 years ago, the whole business of white powder trafficking. Additionally, he added that the Supreme Court's decision upheld that forfeiture is included in the definition of fine as a whole. He stated, the argument here is this: does forfeiture fall within the ambit of Section 137, 1D, in brackets of the Constitution? The Constitution does not specifically refer to forfeiture. He talks about fines. Can fine make forfeiture? Can fine mean forfeiture? I beg your pardon. We have seen the Supreme Court decision placed in the public space of our country, particularly the Supreme Court decision in which the CJN of Nigeria, Justice Alowora, read the leaked judgment, where he basically quartered forfeiture around the whole context of fine. Buttressing further, he said, when you forge something, it falls within the whole business of fine. So that's the whole argument of Obi. So that is the whole argument of Obi. Recall that on April 11, the APC insisted that Bola Tinubu, its candidate for February 25th presidential election, was not charged with any drug-related crimes, resulting in a forfeiture of $460,000 to the United States government in 1993. This argument was made through the APC legal team at the Presidential Election Petitions Court at the Court of Appeal in Abuja. In defending its principal, Tinubu, the team, led by Lateef Hassan, denied the Labour Party's presidential candidate assumption that his principal had been found guilty due to the seized funds. The funds in the aforementioned accounts, which were held by two commercial banks, were the subject of a civil forfeiture proceeding and not a criminal forfeiture proceeding. The APC notified the Presidential Election Petition Court in case number 93C4483. His defense team had claimed that the forfeiture was just a degree of forfeiture of $460,000 to the U.S. as a result of the parties to the case reaching a settlement of claim, not a fine. The said decision is not against the second respondent, TINUBU, but against the funds in the various accounts opened in the name of Bola Tinubu with First Heritage Bank and Citibank, NA, the lawyers declared. The side argued that Tinubu never admitted to engaging in drug-related companies, fund fraud, or money laundering in the proceedings leading to the forfeiture of the aforementioned sum. The party also argued that this issue had been resolved as early as 2003 when Tinubu's criminal record was ruled out after a request to the federal government made through the U.S. consulate in Nigeria. Well, as you can see, Nigerians, this case is going to be very, very tough for the Nigerian judiciary. Yes, with all these and the laws have already, stipulate what happens when you are involved in such a thing and all that. It's going to be very tough. Nigerians are watching Nigerian judiciary to see how they will go about this. Say that they talk, say, na court na im be last man hope. But make we see wetin go happen last. I'm dropping it here, guys. Kindly share your thoughts below the comment section. Please do not forget to subscribe to this channel